couple of other points about the application management policy. There's always talk about unsolicited information, that you should not submit any unsolicited information for fear of having your application refused. There are some types of unsolicited information that are acceptable, that will allow your product to remain in queue and be evaluated, but that will help substantiate either the safety or efficacy of your product. So if you have information from other regulatory jurisdictions supporting safety and efficacy, that can be submitted. If you have updated safety labeling, if you're putting on another contraindication or a risk or warning, that would be acceptable. You can make changes to the non-medicinal ingredients and or the brand names, as long as this does not affect the quality or safety or efficacy of the product. Again, you can remove a proposed claim if you've decided it's no longer applicable. You do, however, have to have at least one claim for a natural health product. You can make changes if pre-cleared information, for example, is published after you've submitted your application. You can revise your application to align it with that pre-cleared information. This will help expedite the review process. So if you want to change your application to attest to pre-cleared information, that is acceptable. And as well, if you want to submit the finished product specifications form, that is other unsolicited information that is acceptable. So changes can be made as long as they don't impact the safety, efficacy, or quality of your product. Unsolicited information that is unacceptable basically relates to any changes that will have an effect on the safety, efficacy, or quality of your product. So if you add medicinal ingredients, if you make new claims, if you make any changes to dosing, route of administration, or the dosage forms, these are unacceptable and could result in your application being refused. Again, part of the application management process, there was a discussion of performance standards. Now, these are proposed performance standards, with the exception of the 60-day disposition clause for compendial applications. These are only proposed standards. The 60-day disposition for compendial applications is legislated in law, but that is the only legally binding time frame that the NHPD is dealing with now. So what they're proposing is that for complete applications that are submitted electronically, and again, these criteria must be met, these are the timelines that they are aiming for. So for applications attesting to pre-cleared information, so those would be compendial applications, applications attesting to abbreviated labeling standards or general labeling standards, or any amendments that are referring to pre-cleared information. They are looking at administrative processing for completeness, a total of 10 days, and then an initial assessment that will last 50 days. So ultimately, they are hoping to either issue a license or refuse a license within 60 days. So again, this is specific to pre-cleared information, and with the exception of compendial applications, these are proposed performance standards. When we're looking at applications that are attesting to non-pre-cleared information, so these would be non-traditional, traditional, homeopathic applications, or any amendments that affect the safety, efficacy, and quality, we're looking at a total of 180 days from the initial date of receipt. So this is, again, an initial screening of the application for completeness, which would take about 10 days, and an initial assessment of the information, the evidence being submitted, for another 20 days. So optimally, within 30 days, you would either get an acknowledgement notice, an application acceptance letter that has your submission number in it, and information about how you can apply for an exemption number, or you could get a refusal. As I mentioned before, no early information request notices are being issued. So if your application is accepted, then the full assessment should take approximately 90 days. If an IRN is issued, an information request notice, then the applicant has 30 days to respond. This 30-day response time is not taken into consideration with their performance standard. Once the assessment, or once the response is received, they're looking at approximately 45 days to assess that response, and then preparing the regulatory decision, whether it's a license or a refusal, within 15 days. So the total from start to finish to evaluate an application that is not attesting to pre-cleared information would be 180 days. And this is slightly longer than the timelines for the exemption number. With the exemption number, the 180 days does not start until you receive your submission number. So as you can see, the exemption number is really a fallback position for the Natural Health Products Directorate if they're unable to issue a licensing decision within that 180 days target that they've set for themselves. And this, it's a little bit difficult to see. It might be bigger on your screen, but you can reference the application management guidance document that is, I believe, on the website now. This is the last page of the document, and it sets it out a little bit clearer what your timelines are. And this is good to reference when you're trying to determine your access to the Canadian market with new products. But again, bear in mind that you need to leave at least 4 to 6 weeks to add any ingredients to the Natural Health Products ingredient database. The other policy that came into place is, and the one that is probably causing the most concern within the industry, is the revised compliance and enforcement policy. This policy came into effect on August 27th of this year, and again, you can find the link there where it is posted on the Natural Health Products Directorate website. The policy, the intent of this policy is that all products should be licensed. And that is the intent of the Natural Health Products Regulations, that all products would have a license before they went to market. So the industry has had a bit of flexibility over the last 6 years, but we're moving towards a period where there will be full compliance with the Natural Health Products Regulations. So as I say, the expectation is that by February 2011, products without licenses should not be offered for sale in Canada. Between now and February of 2011, it is a transition period. Submission numbers are still acceptable. You can import products with a submission number alone. You can sell them with just a submission number, but there will be a period of education and compliance promotion between now and February. Again, this compliance policy is broader in scope than the previous one. The previous compliance policy specifically looked at the licensing of natural health products based on various categories and based on the risk they pose. This document will look at other violations, including potential GMP violations, labeling violations, Schedule A claims, etc. So this will not just focus on product composition, but as well as labeling, claims, manufacturing standards, adulterants, etc. So again, moving forward, submission numbers will not be sufficient come February 1st, 2011. The expectation is that all products will be licensed or have an exemption number. So to be on the safe side, it's recommended that you get your applications in as soon as possible. If you've been in queue for 3 or 4 months prior to February 1st with a complete application, then the chances of having compliance action taken against your product are less than if you had submitted your application on January the 31st. And again, products being imported at Canada are at increased risk of compliance action because it's easier to identify non-compliant products as they're crossing the border. So again, there's a need to have a license or an exemption number by February 1st of 2011. You need to keep in mind when you are preparing your applications for product licenses that you need to have all your ingredients in the database. You need to consider whether there is pre-cleared information that will help expedite the review of your application, and as well, it needs to be, if at all possible, an electronic application if you're hoping to have it reviewed within the proposed performance target. So just some numbers, if we're looking at a compendial application, the latest you could hope to submit it and still get a license by the beginning of February, and I think I've calculated wrong, that should be December 1st. So if you get your application in by December 1st for a compendial application, then you could potentially have your license by February 1st, but don't leave it any longer. Again, as you can see, 180 days for a non-pre-cleared information application submitted today would take you into April, so you're already past the February deadline. And excuse me, if you're looking at an exemption number, if you applied today, the earliest you would get an exemption number would be May of 2011. So again, these are best case scenarios, and these numbers do need to be taken into consideration as you move forward and assess your market strategy. A couple of comments. The NHPD has been hosting web-based training sessions to help educate stakeholders about all the changes that have been occurring. They're on their second round of these webinars, and unfortunately there's only a couple left that are still available. The deadlines, the timelines have passed. The second last one, the EPLA for homeopathic and homeopathic labeling standard, it is being offered tomorrow, but in French only. And the e-submission builder is being offered on October the 7th in French and English. And there should be more information, I believe, on the NHPD's website about those. They say this is the second round for these same sessions, so there may be a third round coming.